today, so I'm pinch hitting for her. My name's Cathy Roberts, and I'm a senior paralegal working in the Albany office of the Empire Justice Center. I'm delivering these remarks on behalf of Amy Schwartz, who's our senior staff attorney who coordinates our organization's statewide domestic violence legal program out of our Rochester office. The Empire Justice Center is a statewide support center for legal services programs. Among other things, we provide research and training, act as an informational clearinghouse, undertake impact litigation, and engage in legislative and administrative advocacy. In addition to our offices in Albany and Rochester, we also have offices on White Plains and on Long Island. We sincerely appreciate the invitation and the unique opportunity to be here today to highlight several critical issues impacting victims of domestic violence. Before I begin, I want to be sure to thank Senator Hassel-Thompson for her steadfast leadership on these issues and the Senate Democratic Conference as a whole, as well as Assemblymember Pretlow for sponsoring this forum. You have our written testimony. I'm going to summarize today, and our comments are going to focus on domestic violence-related bills that address anti-discrimination protections in housing and public accommodations for victims of domestic violence, and legislation aimed at disarming domestic violence perpetrators. I think a lot of what is in our testimony echoes what you've heard from previous speakers today. I'm going to start by talking about Bill S-3784, prohibiting discrimination against victims of domestic violence, sponsored by Senator Hassel-Thompson and Assemblymember Stevenson. As you've already heard today from many of the speakers, domestic violence survivors face tremendous economic and housing-related hurdles when they attempt to break free of an abuser. Often the choices are poor: remain with an abuser or become homeless. Previous speakers have already testified that a leading cause of homelessness for women and children is domestic violence. For many families forced to flee their houses and their apartments, domestic violence programs and homeless shelters provide a crucial safe haven. However, as you know, these services are limited and traditionally crisis-oriented, so they provide families with few longer-term solutions to their housing needs. A dearth of affordable private housing stock, public housing or voucher programs such as Section 8 in many communities poses other challenges for those transitioning from shelters or those in need of permanent housing. To compound this problem, housing discrimination by landlords and agents is a widespread issue for individuals who are abused. Despite the fact that they may be innocent tenants, domestic violence survivors regularly face evictions based on the violent and criminal acts perpetrated upon them by their abusers, simply because the landlord became aware of the abuse or the survivor called the police or sought the assistance of the courts. Some survivors transitioning from residential domestic violence shelters into the larger community report being denied housing when current or potential landlords or sellers learn of their history and their situation. Victims residing in certain communities may run afoul of local chronic nuisance ordinances and may suffer eviction or other penalties where frequent law enforcement calls for emergency assistance tag them as a, quote, problem. In effect, practices such as these blame and punish victims for the violent acts of their abuser against whom they wield no control. Doubtless, such discriminatory acts have an overall chilling effect on victims who reasonably fear that calling the police for help or taking other measures to protect themselves and their children will result in an eviction or an inability to secure appropriate housing for the family. On a local level, both Westchester and Monroe counties have passed anti-discrimination protections for victims living within their borders. Despite these local laws, however, most victims in New York remain unprotected. That's why we are very thrilled about S-3784, which would address this problem by prohibiting housing discrimination against victims of domestic violence. As you've heard from other speakers today, the Executive Law Section 292 and 296, the Human Rights Law, under this proposed legislation, would include domestic violence victim status to the list of bases that cannot be used to deny an individual the right to purchase, rent, lease, or otherwise inhabit private or publicly assisted housing accommodations. Gathering information or inquiries related to victim status that help an abused individual to retain housing or secure assistance would be permissible activities. The bill also contains broad definition of victim of domestic violence thereby providing protection to persons in both dating and other intimate and familial relationships. Landlords and sellers of property should not be permitted to discriminate against domestic violence victims based on assumptions about the effect that their tenancy or home ownership may have on property or other persons. The denial of tenancy or sale of property, eviction, or the imposition of special rules and conditions upon the victim as a condition of occupancy are all punitive and discriminatory practices this bill seeks to curtail. Also, importantly, this bill prohibits discrimination against victims of domestic violence in both public accommodations and education. For many years, Empire Justice Center has supported housing discrimination-related legislation, and we look forward to seeing the bill enacted into law in the near future. The next bill I'm going to touch on is S1003A, Judicial Inquiry into Possession and Location of Firearms, sponsored by Senator Peralta. As you well know, the time period when a victim of domestic violence attempts to exit an abusive relationship can be the most potentially dangerous. Called separation violence, both research studies and anecdotal experience indicate that this type of retaliatory abuse may be triggered by conduct such as ending a dating relationship, physically separating, commencing a divorce, or seeking an order of protection. One federal study on homicide among intimate partners found that female intimate partners are more likely to be murdered with a firearm than all other means combined, and concluded that the figures demonstrate the importance of reducing access to firearms in households affected by intimate partner violence. As you've heard from other speakers, statistics show that over a quarter of domestic homicides statewide involve firearms, with more than 40% of these gun-related homicides occurring outside of New York City. New York has enacted several critical laws that require an abuser's firearm be removed and their license to carry revoked. However, given the alarming fatality-related statistics, more comprehensive safeguards should be in place to help keep families safe by getting guns out of the hands of abusers. There should be no question that judges presiding over cases involving domestic violence should utilize every opportunity to inquire about the presence of firearms. New York's family offense petition contains several important questions addressing a respondent's history with or access to firearms and other dangerous instruments. However, victims may not be aware of any weapons or may not know how many weapons an abuser possesses. Further, at any point after initial proceedings, an abuser might acquire a firearm, such as before a final hearing or during a modification or violation proceedings. In criminal proceedings, the victim may not be participating in all phases of prosecution, and the courts may not have the benefit of the victim's input regarding the defendant's access to or use of firearms. In criminal proceedings, courts can make an inquiry at numerous stages where an order of protection may be issued, such as at arraignment, bail hearing, plea, or sentencing. While New York's existing civil and criminal laws do allow for judicial revocation of firearms license or surrender or removal of weapons when an order of protection is issued, this relief has been discussed by other speakers, may be discretionary based on the nature of the case. In order to issue the most appropriate and comprehensive order of protection, a court should have all necessary information at hand so that the order may truly further the purpose of protection. Failure to disarm abusers may have tragic consequences, not only for victims, but for domestic violence perpetrators who may turn the gun on themselves or their children. Bill S1003A seeks to remedy this issue by requiring judges to specifically inquire as to the ownership and possession of firearms whenever a temporary or permanent order of protection is issued. It would also require the inquiry as to the location of the weapons. And while some courts do make these inquiries as a matter of course, the practice likely varies from county to county as well as from judge to judge. Consistency in practice will not only promote public safety at large, but will send a zero-tolerance message to individual abusers that the protection of victims and children is paramount. We are in favor of legislation advancing the best practice of judicial inquiries regarding weapons. We would also welcome an expansion of the bill's language to specify that inquiries be made directly to the respondent or defendant where possible, and that inquiries be conducted on the record while the individual is under oath. Such inquiry would allow the court to clarify the current status and location of a weapon, For example, if it was allegedly sold or transferred in a bona fide transaction, when and to whom, and to utilize the accountability of court proceedings to reinforce the bill's important goals, keeping families safe. We look forward to continued conversations with the Senate Democratic Conference around this important legislation. Finally, our written testimony addresses Bill S-764, mandatory firearms restrictions upon orders of protection. However, in the interest of time, I'll let you read those comments. I want to thank you very much for the opportunity to testify here today and for your leadership on these important issues.
Thank you.